Okay, so let's commence. This term, we have two course units, which are almost the same. That is criminal procedure and then civil procedure. As it has been our norm that we categorize the procedure units and we put them aside, and then also the transactional and we put them aside. Just know that it has always been a norm that in third term work, you always get a number. And that's how LDC operates. The reason is that they give you things that you still recall, okay? They give you things that you still recall so that at least we are able to get some good marks. So this implies that you have to ensure that at least you have grasped the basics of third term, because it is the only opportunity you have to change your marks. You don't know how orals went. Some of you are lucky, maybe new, but this time around, we have to prepare for the final exam. So our schedule is going to change a little bit because this term, you need what we call personal reading at its best. We need that touch of question interpretation. So our schedule may change a little bit, but inshallah, we shall adhere to the same, okay? So this time round, we have criminal. If you appreciated the criminal of last term, this criminal will always be simple, okay? Reason, we read exactly the same things, but in a different way. How? Okay? When you are dealing with appeals, last year, we categorized our work of criminal using wordings. The first word we had was a complainant. The second word we had was a suspect. The third word we had was accused. Then the fourth word we had was a convict. Then the last word we had was appellant. So when you look at how your work was, you had to deal with, you dealt with the complainant, the suspect, accused, and then the convict. So that means in your last workshop of criminal, you had to appreciate how we convict. You had to be able to read the sentencing guidelines and understand what are the conditions we base on when we are convicting someone. What are the rights of an accused person? So under such circumstances, you'll be able to appreciate that at this point, we are dealing with the last person, who is the appellant. Okay? Who is the appellant? Because once you are convicted, the last wording of the judgment, is very clear that you have a right to appeal. So that means the rights of a convict, we have one, a right to appeal, and then two, a right to apply for bail pending appeal. A right to apply for bail pending appeal. Okay? So you should be able to ask yourself, how best can this convict enjoy these rights we are talking about. Okay, so the biggest challenge with appeal is reading the record. When you look at your workshop, is of just 44 pages, which is very simple to read. But the biggest challenge we have, how are we going to read this? How do we understand this appeal? What are the key features we base on to understand the kind of appeal we are going to deal with? Okay. So when we are looking at appeals, okay, when we are looking at appeals, first things first, okay, first things first, ask yourself, okay, the jurisdictions of the first appeal, the court of first instance, okay. So was the matter in the magistrate's court? Was the matter in the high court? So if it was in the magistrate's court, where am I appealing? So this takes us to what we call categories of appeals. We have a first appeal, a second appeal, and a third appeal. But a third appeal is rare. The best appeals we have are first appeal and second appeal. So it depends the court where you are emanating from. So if the matter emanated from the Chief Magistrate's Court, the first appeal will be in the High Court. If the matter emanated from the High Court, the first appeal shall be to the Court of Appeal. If the matter emanated from the Constitutional Court, the first appeal shall be okay. Sorry for the interruption. I've been off. Okay, so we've been saying that so it depends which court, then so that you can look at, and then when you are dealing with an appeal, the law you read again depends on which type of court you are dealing with. The law that tells you which court are you going in is the law that governs the court of first instance. If the matter was from the magistrate's court, that means if someone is dissatisfied with the judgment of the magistrate's court, the magistrate court's act tells you where to go. So that means the very first law you need to look at will be the MCA. Okay. Then also we have circumstances where we have the record. Yes, you've seen the court where you want to go. How are you going to deal with that court? The biggest challenge we have is what we call formation of the grounds of appeal. Okay. Formation on the grounds of appeal. So now, how do we read this so that we come up with the best grounds of appeal? When you get this record, you start with the charge sheet. Why? Remember, court has the duty to frame charges. So in circumstances where court proceeds on an irregular charge sheet, it is a ground of appeal. Okay? It's a ground of appeal. Then after someone has been charged, this person becomes an accused person. Okay? Once this person becomes an accused person, he will be arraigned in court. Once they bring you to court, you have to do what? You have to take plea. We have to know how you answer against this charge. So that means the second thing you look at is what we call procedure of plea taking. How was the plea recorded? Where the judicial officer adopted a wrong procedure of plea taking, okay, you automatically proceed and also get a ground of appeal there. Okay. Then after plea taking, it depends the plea someone has taken. Once the person has taken a plea of guilty, you only have two grounds of appeal. Mark this, because the chances are high your IA of this week is going to base on a plea of guilt, because I've seen the workshop has a plea of not guilty, because they want you to learn widely on these appeals. So once someone takes a plea of guilty, we shall not have adducing of evidence. So that means we are not going to have a ground on evaluation of evidence. Okay, so that means when it is a plea of guilty, you have only two grounds. One, that the trial magistrate had in fact and law when he adopted a wrong procedure of plea taking. That's one. Because once you plead guilty, you cease to have a right to appeal. You only appeal against the plea and the sentence. So we don't go against the conviction. So then, in circumstances where this person takes a plea of not guilty, like the workshop you have here, this clearly indicates that the accused shall be put to his or her defense. So that means after that, you will be under an obligation to look at what we call evaluation of evidence. Evaluation of evidence. So under this one, first ask yourself, okay, what are the different types of evidence that have been adduced? Okay, that have been adduced. But before you basically base on it, okay, before you basically drill on it, you should make sure you know the law regarding that type of evidence. Okay? You should be knowing how it is handled. So once you read, you identify that the type of evidence that was adduced, one was single identifying witness. So that means you should be knowing how that evidence is adduced. Okay. So once you read the judgment at the end, look at how the judicial officer dealt with such evidence. If you know the law regarding the single identifying witness, so how did the judge deal with this type of evidence? According to the law of evidence, how is this evidence supposed to be dealt with? Courts are hesitant on convicting on evidence of a single identifying witness. So read and analyze. Did the judicial officer convict on such evidence or not? Okay. On such evidence or not? Okay. So if they convicted on such evidence, then you have to teach the judicial officer how that evidence is dealt with. Okay. How that evidence is dealt with. Okay. Then if not, so that means once you see the type, if it was single identifying witness, any slight mistake in evidence is a ground of appeal. Then after that, go to what we call the defense's case. The defense is, in most cases, the defense will raise, okay? The defense will always raise what we call a defense. And the most popular defense that is dealt with is an alibi. So what is the position of the law where the accused raises an alibi? What should court do? So you look at how court handled the alibi. If court did not consider the alibi, then that means it's also ground of appeal. So all those we are looking at evidence. Then after adducing evidence, we are going to what we call a conviction. Okay. Then after you have been convicted, you have to be sentenced. Okay. So now we go to what we call the sentence. How do you tell that this sentence is irregular? Okay. How do you tell that this sentence is irregular? Okay. So I want you to differentiate between, we have what we call harsh and irregular sentence. And then we have what we call illegal sentence. Those two things are different. Harsh and irregular. In such circumstances here, the sentence is provided for under the law. But we have what we call the sentencing guidelines. They guide the judicial officer on how to give a sentence. Okay. So look at the sentencing guidelines. What do they say? What should the judicial officer do before he or she convicts? One, we have what we call mitigating factors, where the mitigating factors put into consideration. First, look at them. Where they, because they have to be put into consideration in the judgment. So you go at the end, okay, of the judgment. You got the end of the judgment and analyze the judgment. Once you see that it was properly dealt with, so you read the judgment and see, for example, this one we have, you just go where he was sentencing down here, okay? Did he put them into consideration? Okay. Then after that, it is also mandatory to put into consideration what we call the time spent on remand. It should be deducted. Okay. So once you see those things when they are missing, that clearly implies that there is a problem somehow, somewhere. Then it also forms a ground of, so you are appealing against the sentence that the judicial officer had in fact and law when he sentenced the appellant to a harsh and irregular sentence. Something becomes irregular where you have not followed the procedure. Okay. Then there is something that is always done that makes it illegal. It is in the Prisons Act and the sentencing guidelines. It is called, remember when you go in prisons, they always check on you to see how you are reforming. Okay. Court has no such powers. Okay. But in, yes, Counsel Kemplin, your hand is up. Yes, Counsel, your hand is up. Is it by mistake? Okay, so now, if you see how we've been moving, so that means in actual sense, if they give you everything has a problem, you should have basically 5 grounds of appeal. 5. But remember, they want you to add those grounds. They want you to be the appellant and the respondent. Okay, so now
could you repeat the 5 grounds, please? Please, the 5 grounds. I think I've captured evidence and the sentencing guidelines.
We said the first one was proceeding on a wrong charge sheet, a defective charge sheet, if it was defective. Then another one, adopting a wrong procedure of plea taking. Okay. And then also okay. So under such circumstances, you should have read the entire record of proceedings. That's why I'm telling you, the final exam is not food. Okay, it's not food, because the criminal paper will be, if you guys are lucky, it will be of like 50 pages. Now imagine if it exceeds 50, then that's a reign of terror. Okay, but these things are easy to summarize briefly. So now, when you are dealing, we have the questions we ask ourselves. This is the way we read appeals. This is still a general overview. We've not yet started. This is just the general understanding. Then we sit, we analyze the law. Okay, so we are going to analyze the law basing on the following questions. Question 1. Okay, question 1 is whether the convict has a right to appeal. Why? Why do we, that should be your first issue. You should, one, ascertain whether you are within time of appealing. Okay? Then, does the law give you a right to appeal? Because we have matters where we don't appeal. Okay? This guy may be wanting to appeal against something, but when the guy went for a plea of guilt. Okay? So then after, then 2, okay? What are the, once you realize that this person has a ground of, he has a right, then ask yourself, what are the possible grounds of appeal? Sometimes they are called merits of the substantive remedy. Okay. Merits of the substantive remedy, because you have to discuss them. Okay. Then the third one will be, what is the forum and the procedure? Okay. What is the forum and procedure? Then for,
excuse me, Council. I beg your pardon
yes,
on the second one. The second
we
issue.
said, the second one, we said it can be phrased either, what are the possible grounds of appeal? If not, what are the merits of the substantive remedy? Because the workshop is using the word substantive. Okay. Then after that, we got what is the forum and procedure. Then lastly, what are the necessary documents? This talks us what we call commencement of an appeal. Then lastly, we have what are the interim remedies available. Sometimes it's better you be straightforward, you don't beat around the bush, and you say whether it has the right to apply for bail pending appeal. So that's how we are moving on these appeals. So now we are going to learn how we read this record. The fact is the record is huge, okay? It is very huge, okay? And reading it becomes a big problem, okay? Okay, so let's go. Are we ready? Who has, those who are online, who has Kansazawe? Did you have the workshop with you?
Yes. Yes, I do.
Okay, so please get it. So whenever you get the workshop or the IA, whatever the case may be, okay, before you do anything, open the judgment. Okay, open the judgment. Can I on the judgment?
Yes, I am.
Read the title.
The title is, it has Magistrate Grade 1, 14th April 2023.
So now I want you to look at the date, okay, and the court. So after reading the court, it shows that the matter is emanating from what court?
Magistrate Grade 1.
So now, then, after that.
Council, isn't it the Chief Magistrate Court? Council.
Yes.
The heading says in the Chief Magistrate's Court of Machinji.
Yeah, it is a Chief Magistrate's Court, but the matter was handled by Grade 1. Grade 1 has the same powers as Chief. Okay. So that means the matter is emanating from a Chief Magistrate's Court. So now you ask yourself, okay, where am I appealing? Yes, Council?
I'm appealing to the High Court.
So now this means, so now at that point, don't rush. Just know if you are going to deal with an appeal from the magistrate's court to the High Court, from the reading, now get the MCA. Okay? Get the magistrate court act.
Lawrence, uyo muganda wange naye tasobola
Colleagues, my apologies, having dropped out prematurely, but I'm back, okay? So, as I've been submitting that, after reading the title, and you've seen that the matter is emanating from the Chief Magistrate's Court, get the MCA first, okay? Now, then after getting the MCA, you've known that you are going to appeal where? To the High Court, okay? Then get the act that deals with the High Court, which is the trial on indictment, and the Criminal Procedure Code Act. So those are basically the three acts you need as per the workshop. So now we want to see, to answer our first question, whether this guy has a right to appeal. So that means the MCA is telling you when and who can appeal. So we want to see whether this person falls within the meaning of the persons who can appeal. Okay? Who has the MCA? Colleagues who are online? Because if I read, I'll be doing a disservice to you guys.
Which section?
Okay, you have it. Council, go to section 204. Section 204, are you there?
Yes.
Let's go.
So with the heading
Criminal appeals.
Criminal appeal.
Yes.
Then section 204.
Yes.
Criminal appeal, subsection 1. Subject to any other written law and except as provided in this section.
Yes.
An appeal shall lie to the High Court by any person convicted on a trial by a court presided over by a chief magistrate or a magistrate grade 1.
First pause. Okay. So now, is our client a convict? So you take the first thing. He's a convict. Okay. The matter was provided over by chief or grade 1. It is grade 1, you also tick. Okay. So that is our first appeal. So it is an appeal from the Chief Magistrate Court to the High Court. Now you ask yourself, what are the prerequisites of this appeal? Council, go to subsection 2 now. Now we want to see if he's a convict, that we are sure, and then his matter was presided over by a G1. So what does he now fit? Council, let's go to subsection 2 now.
Subsection 2. Any appeal under subsection 1 may be on a matter of fact as well as on a matter of law.
So that means all first appeals are on matters of law and fact. So that means, that explains why when we are formulating a ground of appeal, we say that the trial magistrate add in fact and law, because we appeal on both matters of law and fact because of this section. Okay, it's section 204 subsection 2. Okay, then Council, let's go to subsection 3.
Subsection 3. No appeal shall be allowed in the case of any person who has pleaded guilty and has been convicted on that plea by a magistrate's court, except
so now,
as to the legality.
Okay, the first thing that gives you a right to appeal, okay, when you have not taken a plea of guilty. So did our client take a plea of guilty or not guilty?
Not guilty.
So that means he passes the first test. Okay. Then let's go to subsection 4. We are seeing whether this guy has a right to appeal.
Subsection 4.
Mhm.
No appeal shall be allowed in a case where a court presided over by a chief magistrate or a magistrate grade 1 has passed a sentence of imprisonment not exceeding 1 month only, or a fine not exceeding 100 shillings only.
So now you see, so the punishments we have in our judgment, you turn to the judgment at the back. Okay, counsel, turn to the judgment. You see what punishments were given to your client. Okay.
Yes.
What punishments?
So count 1, he was given 1 year's imprisonment. And count 2, he was given 5 years imprisonment.
So now you see. So he also has a right to appeal, not so?
Yes.
Are we together?
Yes.
Okay. So now, let's proceed to subsection 5. Now,
pardon, the section of MCA.
It's section 204. It's the section we are reading in its entirety. It's the only section that you basically run in this workshop. Once you read it and understand it, the rest it's a walkover. Counsel, proceed.
Subsection 5. Where an accused person has been acquitted by a magistrate court, that the director of public prosecutions may appeal or sanction an appeal in such a manner as may be prescribed by the minister by statutory instrument on the ground
what does that mean? Who can appeal? The DPP or the convict? So where the accused has been acquitted, the director of public prosecutions has a right to appeal against the conviction. Okay? Do you know why we have Uganda versus Katoka when it is an appeal? That's where the DPP appeals. Okay?
So it continues.
Proceed.
May appeal on the ground that the acquittal is erroneous in law.
So they're giving you the grounds upon which the DPP can appeal. Okay? Proceed, counsel.
To the High Court, where the accused person has been acquitted by a court presided over by a chief magistrate or magistrate grade 1.
Okay. So now we've seen, okay, how we appeal, not so? So then, counsel, go to the Criminal Procedure Code Act, section 28.
Section 28.
Yes.
Okay, it's under part 3 that has the heading appeals.
I want you to read
28,
that.
notice that.
Read section 28 very well.
Okay, section
28. 28 of what?
Of the Criminal Procedure Code Act. Yes, counsel, proceed.
Section 28, notice of appeal.
Yes.
Subsection
So
1.
first stop there. First stop there. So that means every appeal in criminal is commenced by way of a notice of appeal. We shall see its contents later. Okay. Let's go on.
Subsection 1. Every appeal shall be commenced by a notice in writing, which shall be signed by the appellant or an advocate on his behalf, and shall be lodged with the registrar within 14 days of the date of judgment or order from which the appeal is preferred.
Now go and check on your judgment. Behind. When was that judgment delivered? When was it delivered?
On 3rd May 2023.
Count from 3rd May to today. How many days? And when you are reading the act, okay? When you are reading the act, okay? It says within 14 days. That means weekends are inclusive. The act will tell you 14 working days. 14 days. Okay? So you should be so keen with that. Okay? How many days?
16 days.
16 days have passed. Do you have a right to appeal?
No, you don't.
So that means your client has no right? The section is very clear. Within 14 days. Before you will start, you get grounds of appeal, you get what and everything, my dear. So you're formulating grounds where your client has no right of appeal. So where are you going to take the grounds? You have your own court. So now, we've been answering issue 1. Does your client have a right to appeal? Now, how do you cure that? That is the question. Okay? How do we cure that? Yes? So you're going to tell the client we can't appeal. Yes?
Counsel Kunya talks about extension, but we do not know how.
Yes, he talks about it. Counsel kindly extend the time. So that means we now mark this. Your workshop 2 should be with bail. Workshop 1 has an application of extension of time. So they give you a substantive remedy and the interim remedy. So now, yes.
Actually, I'm seeing here under section 31 is where that interim remedy comes in, because the heading is application for extension of time.
So now let's go to section 31. So because now we've seen that our client has no right, so we have to first create a right. We have to first create a right for our client. Okay, let's read section 31 now.
Section 31, subsection 1. An application to extend the time for lodging a notice of appeal or grounds of appeal under section 28(1) or 3 shall be made in writing to the registrar of the appellate court and shall be supported by an affidavit specifying the grounds for the
So
application.
now I want you to underline the word of the appellant court, okay? Of the appellant court. So under which court are we appealing?
High Court.
Court.
High Court. So now, how do we apply? What is the mode of application? What is the mode of application? Counsel, the reason why I was telling you underline the appellant court, okay? Underline the appellant court. We are appealing to the high court, not so. How do we make applications to the high court? Counsel, go to the criminal procedure application rules. Criminal procedure application rules. Are you there?
Yes.
Read rule 2.
Applications in criminal cases.
Yes.
All applications to the High Court in criminal cases shall usually be in writing, and where evidence is necessary, be supported by an affidavit.
So this means it is by notes of motion.
Motion.
So now, okay, that is the Judicature Criminal Procedure Application Rules, Rule 2. Okay. Okay. Now, we've seen the mode of application, not so?
Yes.
Also read rule 4 before you leave that place. Read rule 4.
Rule 4, notice of application. Notice of an application to the High Court shall be given to the Director of Public Prosecution, and notice of an application to a magistrate shall be given to police.
Okay.
In
so
each
now,
case,
where are we applying?
High Court.
High Court. So that means, okay, our application is going to be served to who?
The DPP.
Exactly. Okay. So now, we presume we have applied the extension of time, not so? And the application has been granted. So that means now our client has a right of appeal. Not so? Now our client has a right of appeal. Any question up to that point?
I want to know here where you talked of serving the DPP.
Yes, once you file an application, you have to serve. But where do you serve? You serve the Director of Public Prosecution, because they have to appear and defend the application.
The law, sir?
It is Rule 4 of the Judicature Criminal Procedure Application Rules.
Judicature Criminal
Procedure Application Rules. So now, our client has been given a right to appeal. That's the presumption. But the question is, what grounds are you going to put in that affidavit? What grounds are you going to put in that affidavit? Yes. What grounds are you going to put in that application? Counsel Zawedi, what grounds are you going to put? Counsel Vanessa. Counsel Vanessa. what are your intended grounds to incorporate in your application, because your client is out of time. Okay? Your client is out of time. Council Joan. Basically, we use two grounds. One, the appellant was detained. His detention, he's delayed to give instructions. Okay? He delayed. Then poverty. Those are the grounds they always put in that application. Okay? He was convicted, and upon conviction, he was sentenced and sent to prisons. So he had no access to an advocate. Then secondly, financial. Simple as that. Those are the two justifiable reasons why we always apply for extension of time. Okay? So counsel for the week, you should be very, very vigilant. Yes, we have counsel for the week this week, you know, so you should be very vigilant. This is a very dangerous area, I'm telling you. Okay? So now, our client has been granted leave. So he has now a right to never proceed without ascertaining whether your client has a right to appeal. The final exam is going to look simple, but it is going to be having such problems. I'm telling you. Okay? So now, what was our second issue? Council Aisha,
What are
what are the possible
grounds or merits of substantive something?
Okay, so
What are the possible grounds?
So now, that is the hardest and the simplest somehow, because once you learn the art of getting the grounds of appeal, it becomes very simple to deal with. But getting them is where the problem emanates from. How? As I told you that our criminal is a procedural course unit. If you didn't understand last year's work, appeals will be hard, because the grounds you get them from the procedure preceding to appeal. That means we have charge sheet, plea, submissions on no case to answer, examination, and then reading the judgment. So now, how are we dealing with this? So, whenever you are reading and you want to get the grounds of appeal, okay, you first go to the charge sheet. Okay? Council, take us to the charge sheet. It's the first.
Yes.
Okay. Do you have the charge sheet?
Yes, I do.
Okay. So now read the charge sheet. Here we are looking for grounds of appeal. The judgment will be the last thing we read. Okay. Council, take us to the charge sheet.
Police form 53. Charge.
So when you are reading a charge sheet, always look at the statement. The
statement of offense.
Yes.
Is criminal trespass contrary to section 302 of the Penal Code Act.
So now what you do, you first, once you see the section, you open the penal code. You ascertain whether it is the exact section. Because these guys are funny. They will give you a section, they know you don't read when it doesn't match with the offense. For you rush very fast Okay, you get it. So we have to read smart and with passion. So you first run to the penal code. You ascertain whether it is the exact section. What if we gave you 3020 304? The charge sheet reads criminal trespass contrary to section this and this. But when you go to the section, when the offense does not exist, so that means that charge sheet is effective. And remember, court has the powers to amend. Okay, so when you look at our penal code, is it the right section?
Yes, it is.
Then go to the second count as well.
The second counts statement of offense, malicious damage to property, contrary to section 335(1) of the Penal Code Act.
Also, go and check it.
That one
Okay,
is true.
it is also correct, yeah?
Yes.
So now that means we don't have a ground there. We are good to go. So that means the triumph, and then before I proceed, do you know why we use the trial judge or the trial magistrate? Yes? Yes? When the
Counsel, we can't
matter,
ascertain what you
because I keep on referring the trial judge, the trial magistrate. Do you know why we use trial judge or trial magistrate? We use that word when there was a trial in the court of first instance. On the first appeal, we used, so that means if it is the first appeal from the High Court to the Court of Appeal, we use trial judge. If it is a first appeal from the Magistrates Court, we use the trial magistrate. So counsel, proceed. So now, that means if we've read our charge sheet and our charge sheet is not defective, we don't have a ground of appeal. Then you go to the second thing you should read. Then you go to plea taking. At this point, we presume you know the law relating to plea taking of page. You know all the necessary steps. So when you are reading this record, you should be re-echoing Adan versus Republic. Any step that was missed, it is a ground of appeal. Okay? So if you didn't read it, kindly sit down in a humble way and read that case. Okay? Counsel, take us to the plea taking, to the page of plea taking now. We want to see, okay, was the right procedure followed? Okay? Because after this person is being charged, becomes an accused person. Then an accused person should be read the charge sheet and he or she pleads. So let's go to plea. How did this person plead? And how was the procedure followed? Yes, counsel. Anyone to take us there?
So where there is charges read and explained to the accused in Luganda to their understanding.
So
Then
that is the
count
procedure.
one, I have
Mhm.
okay. Count one, I have understood the charge, it is not true. Count two, I have understood the charge, it is not true. Then court, plea of not guilty entered on count one. Then count two, I have understood the charge, it is not true. Then plea of not guilty entered on count two.
So now you first stop there. Stop there. Okay. Counsel, do you know the procedure of plea taking? Was the right procedure followed or not? Google Yarden versus Republic. It will give you the procedure. Look at it as you look at this, and you see, is that the right procedure as per the law? Yes, in that case. Counsel, is that the right procedure? Yes? Oh, we don't know. Hajat Afwa, is that the right procedure for recording a plea? Some of you people forgot the plea, just very fast like that.
Okay, the procedure where the accused makes a plea of guilty, the law confers a discretion on the
Counsel. Okay. Was it a procedure of this? We need a plea of not guilty. So look at the procedure. Okay. He took a plea of not guilty. Okay. What is the procedure of recording a plea of not guilty? You should always be a lawyer who finds a problem. Anyway.
Counsel,
Yes.
when recording that plea of not guilty, it has to, according to Adan versus Republic, the
Yes.
charge and all its ingredients of the offense should be explained to the accused in his language or a language he understands. Then the accused's own words should be recorded, and if it's even a plea, it should be recorded. Then the prosecution should state immediately the facts, and the accused should be given an opportunity to dispute or explain the facts or to add any relevant fact. If the accused doesn't agree with the facts or raises any question of his guilt, his reply must be recorded, and that plea of not guilty should be recorded. If there is no charge, if there is no change of plea, then that's when the court will consider whether to pass a conviction or to base on what the convict has stated to determine how the case proceeds.
That is a plea of guilt. Our emphasis is on a plea of not guilty. Counsel.
Can I try?
Yes.
If the trial is before a magistrate with jurisdiction and the accused person pleads not guilty to the charges, the presiding judicial officer shall then explain to the accused the right to apply for bail, and the court may proceed to entertain the application immediately. The power to grant or not to grant bail is a preserve of the court. Considerations for grant of bail include, but are not limited to, gravity of the offense, nature of
I want
the offense.
to look at this procedure. Okay. Yes, Counsel Peter applied for bail. Okay. So don't you feel like we should dispute this procedure? Did the court explain to this person his or her rights?
No, it didn't. It just.
So, Is that the right way how things are supposed to be done?
No,
Yes?
it is not.
Mhm. So what is that?
It is a ground.
Uh-huh. Who is phrasing it?
Council,
Yes.
maybe we would phrase it as failure to follow due procedure in plea taking.
Uh-huh. So the ground is the trial magistrate had in law and facts. The trial magistrate had in law and fact when he adopted a wrong procedure of recording a plea of not guilty. Okay, so that is ground one. Okay, the ground is the trial magistrate had in law and fact when he adopted a wrong procedure of recording a plea of not guilty. So that means how you're going to argue that ground. We are eagerly waiting. So that means you are going to teach court, yeah? Basically, you're going to teach court on the law regarding plea taking. Now, so that means it should be well grounded in the procedure of plea taking. Okay? It should be well grounded in the procedure of plea. So that means you're going to educate them. So whatever ground we identify, you go back, okay, to the law. You read in first term. So that's why I told you, if you didn't appreciate first term, cannot workshop career, but it is hard. Okay, so now after plea taking, what's next? Yes, after plea taking, what next in our procedure? Because this is criminal. Yes, Councillor Daniel. After plea taking, what is the next step in the criminal procedure? You're just doing revision of first term even.
After plea taking, I think we go to prosecution's case.
Aha. So now prosecution is case, okay? Okay. Prosecution is case. So when we are dealing with the prosecution is case, what happens? What happens?
Where the accused person pleads not guilty or denies the substance of the
How does
charges.
the prosecution, how does the prosecution lead its case? That's what I want.
Prosecution opens its case by calling such witnesses as he or she may wish.
So now let's go to what we call examination. Okay, so that means here in examination, what are you looking at? Which evidence was adduced? Then after the evidence, you rush to the judgment and you see which evidence did the judge based on and how did the judge treat this type of evidence. So that means your evidence act should be at a forward play. Okay. Council, let's go. So let's go to what we call examination.
Okay, the examination of the first witness, who is Muslim Makula Abbas. So Muslim Makula Abbas do affirm and state that he's 52 years, a resident of Indeje, businessman. I know all the accused persons. A1 is the chairman, LC1. A2 is a resident of our village. I know why accused persons are in court. The accused entered my land and destroyed my banana plantation. This plantation is on my land at Indeje. This was on the 12th of May 2022 at about midnight. I was physically.
Stop there. At about
Midnight.
you put emphasis on midnight. Go on, Cash.
I was physically at home. We ate supper and went to bed.
Yes.
Then at around midnight, I heard sounds outside my house. It had rained on that day. It was cloudy.
Underline it had rained and cloudy.
It was cloudy, but there was moonlight and I could see people in my garden. On the fateful day, I saw A1 with a panga and other people in my garden, and A1 started cutting my banana plantation.
Yes.
In the course of time, other people who had pangas also joined and cut my banana plantation. Among these people was A2. I was peeping through my bedroom window, which is 12 feet away.
Our underline peeping 12 feet away.
There was moonlight and it helped me identify the accused person. They claimed that they were opening a road for the people. Accused persons cut about 70 meters of the banana plantation and 38 steps of the bananas. All these steps of bananas were 7 months old. I have been on this land since 1990 and I'm the Chibanja holder.
Underline 1990.
In 2000, I created a road on my land for the public to pass, and this road still exists. The road is not where I planted matoke. This road is between my land and that of Hussein Chisolo. I confirm that my matoke was cut down by the accused person plus other people I did not recognize. However, the year 2017, Hussein sold part of this land to some woman. This woman now diverted the road to my land. I informed our LC1 chairman, accused one, but he did not help me to restore the road to its original position. The boundaries of my land are very clear. A1 and A2 in the company of other residents destroyed my matoke. I made an alarm, but no one responded. I feared to get out of my house until morning when I went to Luvugumu police station to report this crime.
Underline I feared to get out of my house.
At Luvugumu police station, I was told to go to Chibuye police station and I proceeded there. The police visited the scene of crime, took photos, and LC1 chairman accused 1 and accused 2 were summoned to police and consequently charged, hence this matter. I have no grudge with accused.
That is what called examination in chief. Counsel, go to cross-examination.
Cross-examination by counsel. Accused 1 is my relative. Accused 2 is General Secretary of Local Council 1. Accused 1 is the area LC1 chairperson. That day I was at my home. It had rained, but there was moonlight, and I was able to identify the 2 out of the group. They were within the banana plantations, but I saw them when they cut them down. I do not recall what they were wearing. I only remember they were holding pangas and cutting my banana plantation. Yes?
Okay, so counsel, proceed and read the. So do you know why you remember that you see the things I'm telling you to underline? Those things are creating what we call contradictions. You know the law regarding contradictions, not so? Because this person says, I recognized them. And then he's saying, I don't remember what they were putting on. Counsel, proceed.
The fence I had erected off, the matoke that was outside the fence near the path or road. This
Now,
road has been in use.
Counsel, hold on. He's saying the fence I had erected fell off. This means he had a fence, okay, that was clearly demarcating his land, not so? But again, he's saying the matoke that was cut was outside the fence. So that means it was outside his demarcations, not so?
Yes.
We proceed, Counsel.
This road has been in use to the public. There was a meeting held in the village to open the boundary. After the accused had cut down my stems, this land was given to me by my mother, and I do not have the agreement.
Underline, I do not have the agreement.
We have sought to resolve this matter.
Okay. Re-examination is not paramount. Let's go to PW2.
Okay, PW2. Islam Makubi Fahad. I do affirm and state that I am 18 years. I stay at Kanyanya in Deje, Machinje.
Mm-hmm.
I am a student of Lubugumu Jamia High School. I am in senior 4. During
Mm-hmm.
holidays, I stay with my parents.
Uh-huh.
Accused 1 is our area LC1 chairperson, and
Mm.
accused 2 is General Secretary LC1 of our area. On
Yes.
12th May 2022 at about 12:30 a.m., accused 1 and accused 2 and other people came to our home. They were holding hoes, panga, sticks, and slashers. We
Mhm.
were sleeping but awakened by noises in our compound.
Underline we were
These,
sleeping.
these people started cutting our banana plantation down. The
Mhm.
plantation was of 9 months old and was about 75 meters in length and 10 meters. I was able to
First
identify
wait,
accused
cancel
1 and
Kumao.
accused 2.
Cancel first pause. The boy is saying the plantation was how old?
9 months old.
Come back to the father's statement.
He said 7 months.
He's saying 7 months. You see, those are contradictions. You put a star. Then he's saying that 75 what? Meters in length. Okay, and 10
Yeah.
meters in width.
We did.
You come here. He was giving you how these guys cut the father. He said they cut how big?
70 meters.
You see, he's saying 70 meters and 38 steps. Who is lying who?
They're all lying.
We proceed, counsel.
I was able to identify accused 1 and accused 2 because I have known them for a while. I do not remember if it had rained or not.
Underline that. If this guy was staying in the same house with the father says it had rained. Okay. Now these guys are saying for him he doesn't remember whether it had rained or not. Let's go.
I have no knowledge as to why they did so. I have been in this area for the last 18 years, and I know that this land where the banana plantation was cut belongs to our father. There was a road passing on this land, but someone bought some land from Mr. Chisolo and built a perimeter wall on the road, and the public diverted the road to my father's land. Up to now, the road is on our land. This is all I can state.
Let's go to cross-examination.
Cross-exam. It is true I have lived in this village since birth. The banana plantation was planted before a perimeter wall was built. I still confirm to court that the plantation was there for 9 months. I do not recall if it had rained that day. I recall that I was very scared and thought the people would come to our house and harm us. None of us got out.
Underline, none of us got out.
I do not know whether my father complained about the construction of the perimeter wall on the public land. My father did not replant the bananas on this land to replace the ones which were cut.
So now,
the perimeter wall built on the road caused the public to divert the road to my father's land.
What re-examination?
Re-exam, the banana plantation was planted in 2018. It was planted before the perimeter wall.
It was planted in 2000.
18.
How many months are those? How old were the banana plantations? 9 months.
4 years old.
Let's go to PW3.
PW3, Catholic Impaka Alice, do swear and state, I am 37 years old, police officer attached to Katwe Police Station and a resident of Wandegea Police Barracks. On 13th May 2022, I met accused persons at Katwe Police Station. The complainant is Makula Abbas, who alleged that accused one led a team of residents of Kanyanya Cell to destroy his banana plantation, which he had planted on the land given to him by his mother, Hajat Rukia.
Yes.
With a team of detectives and Soko, we visited the scene of crime. At the scene of crime, we called the parties and mother of the complainant. We summoned Hajat Rukia to show us the demarcation of the road she had given to the public. Hajat Rukia then showed us where the access road was. What I found at the scene of crime was that the access road was encroached onto by another land developer and so narrowed the road. The residents complained to the LC1 chairperson, accused one, who in turn organized residents to enlarge the road, and in so doing, they destroyed the banana plantation of the complainant. The banana plantation was cut down in small pieces. The residents encroached about a meter of the complainant's land.
About what?
A meter.
So the other guys were saying how many meters?
The sun was 75 meters and 10 in width, and then further 70.
We go on.
We then summoned the area LC1 chairman, accused one and his team to come to police to make statements. The accused claimed that it was the complainant who entered the road to plant the banana plantations.
So now the story is changing. Okay.
Yes. Hajat Rukia revealed that Hassan's land had been encroached by the residents under the leadership of the accused, now in court. I had never seen the complainant or the accused person prior to my investigations. Then the cross-exam, Hajat Rukia had no documents in respect of this land. By the time I visited the scene of crime, the crime had been committed. The Soko will come to court to give his findings. We had the opportunity to interview some residents. It is the duty of the LC1 chairman and his secretary to reveal residents whom they mobilized to cut the banana plantations. At one point, Hajat Rukia had wanted out of court settlement, but it failed, hence this matter.
Okay.
Re-exam. There is no perimeter wall on the side of the complainant, but a short wall.
You see? Okay. Let's go on. PW4.
PW4. Arunji Anisha. I am 49 years old, police officer attached to Katwe Police Station, resident of Nsambya Police Barracks. As a Soko, my role is to visit the scene of crime. On 13th May 2022 at 1 p.m., I was contacted by the DC, Alice, and told me that I should visit scene of crime at Kanyanya LC1 in Deje Parish. The case was about criminal trespass and malicious damage, vid in JSD 14-12-5-2022. I proceeded to the scene of crime with Alice and the complainant. Upon reaching the scene of crime, I found that some area had been dug, which was like a road. Around this area was Katmatoke plantation and a fresh boundary mark had been put. During that, the complainant showed the investigating officer his portion of land, where it ends and where he had given the public to pass. I photographed the scene of crime. That is all I did. The photos were handed to the investigating officer and I made my report. Prosecution prayed to tender in the documents and they were tendered in, the photographs. Then in cross-exam, at the time I went to the scene of crime, I went strictly to perform duties of the Sukoin police. I visited the scene of crime the next day after the matter was reported to police.
The next what?
The next day. The issue of the holes seen at the photos will be answered by the investigating officer.
Look at the word holes. The holes seen in the photos. Why? Someone already stated that the complainant dug in the road. Okay, and how we go on.
I am not the investigating officer. I never asked who the owner of the house was, because that is the duty of the investigator. The crops at the scene of crime were destroyed were banana plantations and maize plants. PW5, Rokia. I am 70 years, a housewife and resident of Lufuka zone. I know accused 2 as General Secretary LC1, Kanyanya zone. The complainant is my biological son. The land in issue was given to Abbas, the complainant, by me. I bought this land from late Katamutwe in 1790. It was a Chibanja. I bought this land at 1,150 shillings only. The land which I gave Abbas had no access road, and I provided access road through this land. One day, Abbas called me on the phone that Kahinda, accused 1, had gone with people to his portion of land and were cutting banana plantations. I called Kahinda's phone, but he did not receive. One Chisolo put a kiosk on the access road, which I gave the public to pass. The authorities of the area did not stop Chisolo. This Chisolo also put up a gate on the access road. The access road was large enough to accommodate 2 cars by passing each other.
Now, back someone is saying Chisolo sold that land for some non-so. And that person constructed a perimeter wall. So now Mama is talking about a kiosk and then a gate. So what should we take? Proceed, cars.
The cars cannot properly use their access road because of the gate and the kiosk which Chisolo erected on the access road. The cars now pass on Abbas's land. The kiosk, the trees, gate and fence, and electric pole are all on the access road. A1 and A2 are in court because I am told they cut the complainant's banana plantation.
So now, is that evidence relevant? Yes.
Maybe, though it contradicts what Hassan said.
Okay.
The cross
Let's go
exam.
that one is not
I think-
paramount. Council, go to the we leave the ruling because the judge says that the prosecution has proved the prima facie case. So let's go to the defense's case.
So defense case opens. Kakinda Alex. I am 59 years old, resident of Kanyanya village. I am the area LC1 chairperson of Kanyanya. I know the complainant as a resident of my village, and he is also my cousin brother. I am in court on charges of criminal trespass and malicious damage of banana plantation. On 12th May 2022 at about 8 a.m. to 9 a.m., while I was at home, I received a phone call from Mama Linda, who informed me that there is a problem at Makula's place. I called my LC1 committee members and we proceeded to the scene. At the scene was Makula. PW1 had planted banana plants on the road. People wanted to remove the banana plants, but I stopped the people. The complainant was also present at the scene of crime, and the complainant claimed that where he planted the banana plantation was his land. I do not know who participated in destroying the plantations that night, and I only woke up to the news. The road passes.
Stop there. What is that?
It's so
I
much
think
like
it's alibi. It's putting a defense of alibi.
Cancel. Remember, I told you to understand his defenses. So now,
Defense of alibi.
okay, A1 has raised a defense. Okay.
The road
Okay.
The road passes between the land of the complainant and Hussein Chisolo. Hussein Chisolo was the first to settle in this land. In 2018, we started the mosque to resolve the issue of this road, but the complainant was negative. The complainant then proceeded to carry already cut banana stems and dug holes and planted these steps on the holes on the road.
So, you see, he planted. You see now that the story is changing. Proceed, Council.
On the day the police visited the scene, I was not called to the scene of crime. That's all I can state. Cross exam. The banana cuttings are on the road. It is the residents who removed the banana stems from the road. The road is about 15 meters wide. This is a gazetted road. Prosecution, I pray that DW1 be given time to bring the document to prove that the road in issue is a gazetted road. And the matter was adjourned. To enable DW1 to produce that it's a gazetted road.
Let's go on.
Then bail for also A1 and A2 was extended. Then the next witness, the next part provides that the prosecution said the matter was adjourned till today to enable DW1 to deliver to this court a document that shows it's a gazetted road. Then DW1 said that the said document was not given to me as the authorities were also doubting.
Mhm.
I pray court considers there is no proof that this said road is a gazetted road.
Okay.
Cross
Mhm.
exam. I do not know the names of the people who destroyed the banana plantation. The complainant never brought a complaint to my office.
Okay. Council, go to DW2.
DW2 Mutwedik, 33 years, resident of that area. I have been in this place for 15 years. I am a Mason and I am the secretary LC1 of Kanyanya Cell.
Mhm.
On 12th May 2022 at about 8:30 to 9 a.m., we were at the office of LC1 chairman. Area residents rang that LC1 chairman DW1 complaining that the complainant had dug holes on the road.
Yes.
We proceeded to the scene of crime and we found the residents with pangas and sticks. The residents had cut down the banana plantations which were cut.
So you look at the time. Look at the time. This one is saying AM. The other guys are saying PM. Okay. They're saying 8. The other guys are saying midnight. Okay. So there is a challenge in time. Let's go.
The residents had cut down the banana plantation which was cut had been planted that morning. The complainant was not present and we were told that he had gone to police.
Yes.
The LC1 chairman called the meeting that very time between the LC1 members. While we were still in the meeting, police came. The meeting was at the office of the LC1 chairman. The police served us with summons to report to police, but the same police arrested us and took us to Katwe police station.
Yes.
At Katwe police station, the LC1 and LC2 chairpersons came and requested the police to allow them handle the matter. The issue was not resolved and the police charged us to court for prosecution. Cross-exam. The road existed on the complainant's land, which road the complainant wanted to block by planting banana plantations. We were 10 people who attended that meeting that day. Accused 1 and I were arrested and handed to police of Katwe. The police believed that accused 1 and I committed the offense.
So now, after that, you just go to what we call the judgment. Okay, so we don't need much from this judgment. Okay, we do not need much in this judgment. Okay, what we basically need. So when you are reading, okay, please look at the alibi. Okay, look at the alibi and look at the evidence the judge bases on. Is it the evidence of these guys who have issues with identification? You get it? So at this point, we have 2 issues in our evidence. One, we have identifying evidence where light was not sufficient and the person who saw was only 1. So the type of evidence we are dealing with is single identifying witness. Okay, then ask yourself, what is the law regarding this type of evidence? 1, sufficiency of light. Okay, 2, familiarity. What else? We have proximity. Okay, Yes, counsel. Tuzongereko. Okay, then time spent. So when you, and then, so look at sufficiency of light. Was light enough? Then look at other factors that were there. These guys are all saying we feared to get out. So did they come out? No. So that means chances are high they didn't identify the right. Then 2, we have another issue at hand, the defense of alibi. How does court deal with an alibi once it has been raised? So did the court consider the alibi? You read the judgment and identify. So once you read the judgment and you identify that they were not dealt with, so that means on our first ground of appeal, we are adding on 2. Okay, so we have the general one, that the trial magistrate had in fact and law when he failed to properly evaluate evidence. Because these guys have no one, when you go back to the ingredients of these offenses, you have to prove ownership, not so. Because trespass happens where someone enters land belonging to another person with an intent to destroy or annoy. So look at those ingredients. Did the court, because your client was convicted, so if court, because even this guy is saying that the mom gave him the land, but the mom has no document of ownership, okay? Then also the complainant has no document of ownership. So who is the rightful owner of that land? Don't you think that the first ingredient has not been dealt with rightly? So has court properly evaluated the evidence? Yes. Has court properly evaluated the evidence?
No.
So then you get your second ground. That is a general ground in regards, because the duty of court is to ensure that all evidence is evaluated. So court has failed to execute its obligations in its entirety. So you get your ground 2, okay? That the trial magistrate had in fact, in law and fact, when he failed to properly evaluate the evidence on record. Why? Because you're going to discuss the duty of the first appealant court. You get it? Okay.
Excuse me, counsel.
Yes.
Counsel, on the issue of ownership, what is your take about the evidence of Rukia Nakakawa, who says she's 70 years? She bought the land in 1970 at shillings 1,150.
Is she having proof of ownership? Has she brought the proof? Look at the cross-examination, counsel. She said she doesn't have.
But she's in possession.
She's not in possession. She gave the land to the son. Not so?
Yeah.
But is there proof of giving the son?
Yes. By the son also taking possession, because this is it is a gift, and now, one of the
counsel, what
the
you should know, counsel, what you should know, whenever you're having a matter, you think as defense counsel throughout. Now you're thinking for the prosecution. You're not the prosecution counsel. Think for the defense only. Which you take a walk, they will fight with it. Okay.
Okay.
That's how we deal with such matters. Okay. So that means our first ground we have that the trial magistrate had in law and fact when he failed to properly evaluate the evidence on record, hence coming to a wrong decision occasioning a miscarriage of justice. Why? The ground you phrase has to include the effect. Okay? Has to show how did the failure of the court to do this affect you. Okay?
So,
Yes.
so what if I said
Mm.
that the trial magistrate erred in law and fact when he did not properly evaluate the evidence and ignored the appellant's defense, therefore arriving at a wrong decision? Because
So
you said
that is another ground. Oyagala kwekendeeza maxi.
oh, okay, kale.
It's another ground. But what you should know, they don't deny you an opportunity to raise as many grounds as you can. Okay? Because once you lodge your notice, court will look through your notice of appeal and look at the grounds you've raised, and they see how best they can deal with those grounds. Okay? Are we together? Okay? Let's go on. So now, we've seen that generally, court did not consider the evidence. Now, let's come, we read through this. Judgment is a bit long. So we want to look at the issue of the alibi, okay? Counsel, go to page 16, you read the last paragraph of the judgment.
Page 16 or 19?
It is 16, which has DW1 on his defense told court that.
Okay. DW1 in his defense told court that on the fateful day he was at home between 8 a.m. to 9 a.m. He received a phone call from Mama Linda, who informed him that there was a problem at the home of Makula, DW1. That he summoned his LC1 committee members and they proceeded to the home of the complainant, that at the scene of the crime, PW1 had planted banana plants on the road, and that where he had planted was his land. That the access road passes between the land of PW1 and Chisolo Hussein, that police did not call him to the scene of crime when they visited.
So you see, court looked at that. Okay. Now I want you to go to page 18. Okay. You look at resolution of issue number 3 because it is participation.
Resolution of issue number 3. The evidence of PW1, PW2 is to the effect that accused person physically participated in crimes by entering the land of PW1 and cut the banana plantation of PW1. Even though it was done at midnight or thereafter, the witnesses have informed court that they knew the accused persons before and that there was moonlight which aided them to see. Further, there was a mob of people, but they were able to identify the accused persons they knew before. The distance between them was 12 feet. Refer to the case of Abdallah Nabulere versus Uganda. All in all, the evidence of the prosecution witnesses points to guilt of the accused person.
So now, has court talked about the alibi? Yes?
No.
No, it hasn't.
So that is another ground of appeal. Okay. We go. The trial, who's someone frame for us the ground? Someone frame for us the ground. Let me see who is here. Council Daniel, kindly frame for us. Council Damila Andrew, kindly frame that ground. Frame that ground.
The trial magistrate erred in fact and law when he ignored the defense of alibi for was a prosecution PW. Also guide me from that point.
Council Geoffrey Uganda, kindly submit. Was you related that ground?
So the trial magistrate erred in law and fact when he ignored the appellant's defense of alibi, therefore arriving to a wrong decision.
So that is our next ground over here. That is our next ground of appeal. Then also on that very issue where we are, look at the analysis of the trial judge on the issue of identification in Abdallah Nabule. Did he apply that principle rightly? Yes. Did he apply that principle rightly?
Not really.
Let's get another principle there. Another ground. Let's go. This one will go that the trial judge had in fact and law when he misdirected himself on the law regarding single identifying witness, hence coming to a wrong decision. They just misdirect Baba Chimani, but they are also human, so they just misdirect themselves. Okay, so that's why we use the word because the laws are there regarding that type of evidence, but due to the different ways of handling matters, okay, the judge, the judicial officer misdirected himself. Okay, we go on. So now you see, now the last part you are remaining with is sentence. Okay, is sentence. So at this point, we think you know the entire sentencing guidelines. What guidelines are given? What factors should be considered by a judicial officer when he or she is sentencing someone? Okay. Do anyone with the sentencing guidelines?
Which provision, Council?
Let me first check mine here very well. Let me get mine here. I direct you appropriately. So we have to go to what we call the Judicature Sentencing Guidelines. Okay, they are known as the Constitutional Sentencing Guidelines, practice direction of, okay, because I have its amendment of 2023 of 2013. Yeah. So now, when you're looking at these sentences, each sentence has, so the first thing you do, you go to the penal code, you look at the punishments in the first step. Okay, are we together? Okay, now council, go to regulation 6.
Regulation 6, general sentencing principles.
Yes.
Every court shall, when sentencing an offender, take into account the gravity of the offense, including the degree of culpability of the offender, the nature of the offense, the need for consistency with appropriate sentencing levels and other means of dealing with offenders in respect of similar offenses committed in similar circumstance. Any information provided to the court concerning the effect of the offense on the victim or the community, including victim impact statement or community impact statement. The offender's personal, family, community, or cultural background. Any outcomes of restorative justice processes that have occurred or are likely to occur in relation to the particular case. The circumstances prevailing at the time of the offense was committed up to the time of sentencing. Any previous convictions of the offender or any other circumstances court considers.
Yes. So when you look at those, the section says the court shall. That means it is mandatory. When you look at all these factors, the person who is being convicted is a leader of a community. And this person was given the maximum sentence on both counts. You get it? You put a star. Okay, let's go. Council, go to okay, that was 6. Council, go to 9. You go to 9 sub-regulation 3.
9 sub-regulation 3. The court shall, before imposing a custodial sentence, consider whether the purpose.
Yes, it repeats the same things. Eh? It repeats the same. Yes. Okay. So now, after looking at that, okay, there are other things they should then go to 12. Go to 12.
Hello, Constitution.
Yes.
Hello.
Yes, Council.
Would you please pardon me the law we are reading?
We are reading the Constitutional Sentencing Guidelines.
Okay.
Regulation 12, time to consider sentence. The court shall, upon conviction, allow a reasonable period not exceeding 7 days to determine the appropriate sentence for the offender.
Shall reason. So that means they don't sentence the day the person has been convicted, not so?
Yes.
You will come and read the sentence. You will see when it was granted. Okay. Then go to 14.
General factors to consider at sentencing. In order to determine the appropriate sentence, the court shall take into account matters required to be taken into account by any law and
Okay.
shall make the inquiry in the case.
Okay. Then go to 15.
15, remand period to be taken into account. The court shall take into account any period spent on remand in determining an appropriate sentence.
Okay. Now, you go to page, I think it's page 20. Go to page 20.
Page 20. The court convicts to compensate the complainant 5 million shillings 1 month after serving the sentence.
No, njagala otandikire wano the defense evidence of A1 and A2.
The defense evidence of A1 and A2 was basically lies in light of the evidence of prosecution witnesses. I see nothing remorseful in accused persons when they kept denying the charge. There is no chance of rehabilitating such offenders, criminals, and therefore deserve no mercy of the law.
Now, I want you to underline that he's saying he's not saying any remorsefulness. That means he is preempting what we call allocutus. Allocutus has not yet been done. What if it's not part of the prayers we are going to use when we are mitigating? So for him, he's thinking for us, proceed.
I find the accused persons guilty of the 2 counts as charged, and I do convict accused persons as charged. There are no previous criminal records.
Now you get it. You see what it means. The same day he convicted is the same day he sentenced. We've just looked at the sentencing guidelines. Did he follow the guidelines?
No.
Now you see, now the prosecution is aggravating.
There are no previous criminal records of the convicts. However, the offenses committed by the convicts are rampant and intended to grab land. I pray for deterrent sentence and an order for compensation.
Then go to the defense.
I pray that court be merciful to the convict being a public person.
So now you see, after the allocutus, it's when court should give the sentence. You get it? After putting these factors into, so did court put those factors into consideration? Court convicted this person even before the allocutus. The guy was convicted and sentenced already.
Counsel,
because he said, I find the accused, I find the accused person guilty of the 2 counts as charged, and I do so convict as the persons are charged. Then when he was sentencing, before you give a sentence, you first have to put into these factors. So let's look at the sentence, Counsel.
Counsel, could you pardon the sections we've been reading? The sections in the constitutional sentencing guidelines.
We have 15, we have 12, 6, 9, and 8. Okay.
Thank you.
I'm going to show them. Okay. Counsel, read the sentence now.
I do sentence the convicts on count 1 to 1 year's imprisonment.
When you read the act, this is the maximum. Okay. Yes. When you read the act, this is the maximum. Then read count 2.
I do sentence the convicts to count 2 to 5 years imprisonment.
It is also the maximum. Open page 20 now. The last one,
The convicts to compensate the complainant 5 million 1 month after serving the sentence. I
So
so
now,
order.
what is the, did you see any reasoning why these persons were sentenced like that? Did the court give the reasons?
No.
So what is now at the end, this sentence becomes irregular and harsh. Okay, but what you should know what makes it irregular and what makes it harsh. So what makes it irregular? The factors, the procedure that is supposed to be followed is one, they sentenced to the death, they convicted, the law does not allow. Then two, mitigating factors were not put into consideration. That this makes it harsh, okay? And then besides that, these are two different counts. Are the punishments going to run concurrent or not? Has this person specified or not? So that makes the sentence irregular and harsh. We have our grounds, okay?
Answer, but by the time they labeled them count 1, count 2, haven't they specified these offenses?
Counsel, when you read all the judgments, you are supposed to state that the punishments are running concurrent or not. You've read the judgments, okay? Okay?
Yes.
So now, is that the right counsel? Go to regulation 37 in the first place. Go to regulation 37.
Okay. Regulation 37.
Read the short title.
Sentencing range for criminal trespass.
How you read?
The court shall be guided by the sentencing range specified in Part 5 of the third schedule in determining the appropriate sentence for criminal trespass. The court shall, using the factors in paragraph 38, 39, and determine the sentence in accordance with the sentencing range.
Now, I want you to read 38, basically. There is something I want you to look at.
So, okay, 38 is considerations in determining a sentence for criminal trespass. In for criminal trespass, the court shall take into account the following factors. The nature and prevalence of the offense, the circumstances surrounding the commission of the offense, the relationship between the parties and the conduct of the offense.
Exactly.
The relationship.
These guys are related, they are relatives. So could the court sentence to the maximum? The complainant and the accused are relatives. One is a cousin, brother to the other. Okay? And besides that, this guy is a leader in the society. You can't sentence them to the maximum. Okay? Then counsel, go to 40.
Factors mitigating a sentence for criminal trespass. In considering a sentence for criminal trespass, the court shall take into account the following mitigating factors. Lack of premeditation.
Okay.
Whether the mental disorder or disability of the offender was linked to the commission of the offense. Whether the offender is a first offender with no previous conviction or no relevant or recent conviction. Remorsefulness of the offender, family responsibilities.
Underlying family responsibilities. Okay, you see, so now, yes, counsel, we read the sentence. Did the judge give all those reasons when he was sentencing?
No.
So, workshop is done very fast like that. Okay, we already answered the issue of the forum, which is the High Court, not so? How to proceed? We answered section 38 of the Criminal Procedure Code Act, which says it's by not so appeal. We answered the interim remedy, an application for extension of time. Any question on the workshop? Okay. Any question on the workshop one? Tomorrow we shall be having, or no, Monday we shall have workshop two. Any question, colleagues?
Councillor, we just thank you for opening our minds. It's been a short
So
holiday,
the
but
workshop is as easy as that. But this workshop, you see it as something light, but you have to go back and read the law in order. Okay, so take your time, relax, get these cases, okay, and read them. Read like 3 cases, okay, on the reading list. Read them at least so that you are grounded. I'm very sure you didn't read Adan versus Republic. Most of you didn't read Abdallah Navlele. That's why they keep on occurring the same principles. Okay, so please take your time, refer to that. Start writing your workshop tonight. You saw the complaints these guys have against you, time management. They are going to crush you. That gate is going to be closed by exactly 9. So please take time, relax, relax. These are the last days, okay? Relax and do the best. May I believe you guys can. If you made it in orals, why not now? Okay, so that's all we had for workshop 1. Very brief, like a mini skirt. So let's keep our minds widely open for workshop 2. And even before you go to workshop, just know workshop 2 is basically an appeal from the High Court to the Court of Appeal. So go and buy the Judicature Court of Appeal rules. Okay. Then chances are high it has what we call bail pending appeal. We have to ascertain the constitutionality of bail pending appeal, because Article 23 and Article 28, they are only applicable to a person who is still accused but not a convicted person. So this person is a convict. Are you still presumed innocent or not? So what is the constitutionality of that law? Why do we have bail pending appeal when you have already been convicted? That is the gist of workshop 2. Okay, so let me wish you guys the best. Pray.
Answer.
Yes.
One simple request.
Okay.
When will you get time to possibly guide those who are mooting regarding this workshop?
Which workshop are you using for the moot?
Workshop 1, they sent an
Workshop.
email.
Okay, kindly send
And
me.
they specified that it would be linked to where there is an application.
Yes, it's going to be an application for extension of time then.
Okay, I'll send you the details regarding the moot.
And then I communicate effectively, inshallah.
Okay, thank you.
So, thank you, comrades. May God bless you. This is our last term together, but our relationship is not ending this term. We are comrades in the struggle. We are comrades in the profession, and we shall always move together. So, Lord Heavenly Father, we thank you for this moment. You have given us this short holiday. You have given us life again. Lord, this is our last shot. We pray that your mighty hand of guidance guide us to the road of success. Lord, we rebuke all the plans of the devil. We rebuke sickness. We rebuke accidents. We rebuke the plans of death. We rebuke poverty. Lord, we declare ourselves as winners because you said in the Holy Bible that we shall be heads but not tails. Lord, lead us to the destination because we are destined to be winners, because you said he who believes in you is lucky, and lucky are those who believe without seeing. Lord, we believe, however much we've not seen the exams, we believe we are going to pass them because you are going to guide us. Lord, lead us into the best. Bless our parents, bless our guardians, bless all those who are taking care of us. Lord, protect our country, protect our leaders, and give them the best guidance. Lord, we have rapid shootings in the country, but your mighty protection be upon us. Lord, protect our relationship with these colleagues of mine. Bless us, bless their pockets, bless the persons who are paying tuition for them, protect them abundantly. Lord, create careers for them because outside is hard. You planned for them, continue planning the best. We pray and believe that he who created us is going to answer our prayers. Amen.
Amen.
So let me wish you the best, colleagues. We shall meet physical on Monday, inshallah. May God bless you and keep you well. Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum salam wa rahmatullahi wa barakatuh. Thank you so much.
You're welcome.